consulate cases are a huge headache, and I don't prefer them. I always prefer adjustment of status. But the other thing is that when the Trump administration instructs consular officers to take these sorts of actions, it's much more difficult for the Trump administration to similarly instruct USCIS, because the way they would do it would subject them to lawsuits. A lot of people who are filing family petitions for family members who are residing abroad are understandably really scared right now because of the recent Trump directives to the State Department instructing them to deny more visas by determining that people are subject to the public charge ground of inadmissibility. Specifically, people who might have health problems are going to be targeted now, and people who are of the lower income spectrum are more likely to get targeted now. This directive is just a continuation of Trump 1.0, where they dramatically reduced the flow of consulate cases entering the United States. This is really unfortunate, and I'm curious to see how this plays out. When someone has to decide between adjusting status in the US or consular processing, I've historically always said that all other things being equal, if there are no problems with either option, I have a strong preference for adjusting status in the US. There is this general concept of consular non-reviewability, which just generally, like aside from that concept, it's difficult to appeal or have legal remedies when the consulates abroad make an adverse decision. It's just a huge pain to deal with. Even communicating with them is difficult. Your right to an attorney is limited when you're outside of the United States' jurisdiction, physical boundaries. So anyway, consulate cases are a huge headache, and I don't prefer them. I always prefer adjustment of status. But the other thing is that when the Trump administration instructs consular officers to take these sorts of actions, it's much more difficult for the Trump administration to similarly instruct USCIS, because the way they would do it would subject them to lawsuits. And every time they've tried it during Trump 1.0, during Trump's first administration, there were court actions, court cases that challenged it. So for example, during Trump's first administration, about halfway or like 3/4 of the way through his first term, they created a declaration of self-sufficiency. And this form was like 25 pages, and it was an added form that was now required when you apply for adjustment of status. This form was ridiculous. It required you to list like all of your languages, all of your educational background. Basically, you needed to explain how you're able to support yourself and make money. But the way they went about it violated the Administrative Procedure Act, and so a court struck it down, and it was only in effect for a couple months. So if the Trump administration wants to implement similar standards on people adjusting status, it's much harder for them to do it. And applicants for adjustment of status in the US just tend to have more rights and more procedural rights specifically. And it's easier to become a permanent resident through the adjustment of status process versus consular processing, for most people anyway. Anyway, guys, let's tie this all home with an example of a recent situation that I encountered. I have a client whose mother is in the United States, and she's elderly. She's here on a tourist visa. She's been here for a couple months, and they recently were considering whether or not to apply for her adjustment of status or to consular process. Now, to add some details here, the mother is elderly, unemployed, doesn't have a ton of resources. So now that this new news has come out from the Trump administration about how they're instructing consular officers to deny more visas by determining that people are inadmissible for public charge reasons, that has now shifted the balance in favor of adjusting status for this family, because consular processing is going to take forever and it might not even be successful. They might end up getting denied at the end of it. Whereas adjusting status has a much higher chance of success. And now for parents, there might not even be an interview for some adjustment of status applications. So that shifts the balance dramatically for this family anyway in favor of adjusting status. Whereas before, the mother's plan was to leave and do the consular process. Anyway, this changes the calculation for a lot of people. If you're not sure how to proceed with your family's adjustment of status or green card application or consular process, and you need to speak to an attorney or you want to get some guidance, you could schedule a consultation directly with me, Puyan Darian. You can go to my website, darianlaw.com, to schedule a consultation, or you can click the video description below and there's a direct booking link where you could schedule a consultation in like 5 minutes. If you want to stay up to date with all the recent changes under the Trump administration, policies, policy changes, recommendations directly from an immigration lawyer, be sure to subscribe to my channel, and I'll see you guys next time for another video.